on another salient feature of the Indian Constitution, and we had discussed that the in India we have got a parliamentary system, and then we had discussed the features of parliamentary system, presidential system, and then we had discussed the doctrine of separation of powers. And basically, if we talk about this doctrine of separation of powers, we had also discussed that this doctrine of separation of powers has to be accompanied with by the doctrine of checks and balance. And this doctrine of checks and balance, what does it mean? It means that one organ should put a check on the other organ and balance the power of others. So, this is the aspect that I think we had introduced in the last class, that the doctrine of separation of powers has to be accompanied with by the doctrine of checks and balance. Now, when we talk about this doctrine of checks and balance, in the Indian case, we will be discussing it in detail in the coming classes. That is, when we will be discussing the parliament, we will be discussing the motions, the parliamentary committees, then the questions, that how the parliament puts a control on the executive. When we are discussing the executive, we will be discussing the president's veto power, that is how the president puts a check on the legislature also. So we will be discussing those things in detail. But here in today's class, we will be taking up for discussion the US case, that how in the United States of America the concept of checks and balance works along with the doctrine of separation of powers. क्योंकि क्या होगा ना कि if the question is asked on comparison, तो इंडिया के केस में we'll be discussing it in detail. But if the question is asked, that is doctrine of separation of powers in US and in India, so how to make a comparison? The US case. Now, there is a specific pattern of writing such type of answers if a question is asked, that how the doctrine of checks and balance works in America and in comparison to India also. The headings will be the same. First of all, it is the legislative check on the executive and the judiciary. So this is the first aspect, how the legislature puts a check on the executive and the judiciary in the US. First of all the appointments made by the US President to be ratified by the Senate. Senate is the upper house of US Congress. So, all the appointments, for example, if the US President appoints an ambassador to any country, so after the name is finalized by the US President, then he will refer it to the Senate. The Senate will ratify the name. Ratify means approve. Approve the name, and then only the person will be appointed as an ambassador to that country. Not only this, even if the judges are to be appointed, the judges in the US Supreme Court, after the name is finalized by the US President, the name will be referred to the Senate, not the Congress. Congress means both the houses, only the Senate means only the one house, Senate. And only after the approval of the Senate, the person will be appointed as a judge of the US Supreme Court. So it is not arbitrary. Then secondly, all the international treaties or agreements signed by the US President or on his behalf to be ratified by the Senate. I will be giving here two examples. One, the Treaty of Versailles. The Treaty of Versailles was signed after the First World War. America was also a signatory, but it was not ratified by the Senate. The Senate did not approve it, and it was not binding on America. Then, secondly, the Comprehensive Test Ban Treaty, CTBT. America was one of the first signatories, but it was not approved by the Senate, and it was not binding on America. So, here you see that arbitrarily an international treaty cannot be imposed on America also by the President. Now, if we talk about these two powers of the Senate, because of these two powers, the Senate, the US Senate is termed as the most powerful second chambers of the world. So if we compare the second chambers of the world, for example, in India it is the Rajya Sabha, then in United Kingdom it is the House of Lords, then in France it is the French Senate. So if you compare the second chambers of the world, none of the second chambers have got these powers. In India, forget the Rajya Sabha, even the parliament has no powers with respect to appointments and with respect to the ratification of the international treaties. Then in the UK also, this power is not there with the House of the Commons, House of Lords. And in France also, these powers are not there with the upper house. So, if there is a statement, which one of the following statement is correct? The US Senate is the most powerful second chambers of the world. Now, there can be other question, that is, you may be asked to compare the Rajya Sabha with the US Senate. Rajya Sabha with the US Senate. So in the respect of elections, Rajya Sabha and the US Senate are exactly the same. Means the members of the Rajya Sabha and the Senate are elected for a term of 6 years, and 1/3 of the members they retire every 2 years. It is common to both. Then the Vice President of America, he is the ex officio chairman of the Senate. In India, our Vice President is the ex officio chairman of the Rajya Sabha. These are common things. But when we differentiate it, these powers are additional powers which are there with the Senate. So such type of comparison. So even if the things we are reading today, when it comes to the comparison, you can correlate the things. ऐसे करके we'll need to develop an understanding. Because in our syllabus, what is written? Comparison of the world constitution with the Indian constitution. समझ गया? So it is not feasible on our part that we'll be reading all the constitutions in detail. But wherever it comes, we will have to connect it with the Indian constitution. What is the difference? Then what are the common aspects of it? Then thirdly, the US president and judges of the US Supreme Court can be impeached by the US Congress. So here the impeachment can be done. So you see that there is legislative check on the executive as well as the judiciary. Even the members of the judiciary, that is the judges of the US Supreme Court, can be removed by the process of impeachment. So this is how there is a check on the executive and the judiciary by the legislature. India में भी जब आप लिखोगे ना, you will have to apply the same pattern. Legislative check on the executive and the judiciary. That is through the motions, through the parliamentary committees, through the questions in the parliament. वो I will be discussing. मैं आपको बता दूंगा. ठीक है? How to write it when we are discussing the parliament. This is the first thing. Then coming to the second aspect. The executive check on the legislature. On the legislature. How the executive puts a check on the legislature. Because Senate represents the states in the United States of America. And in comparison to India, if we see that the federal structure in America is better secured. In India, we have got a strong federation, but in America, it is not like that. So the states are involved in such type of process through the Senate. That is the logic why the Senate has been given more powers with respect to the House of Representatives in the United States of America. Yes. You can do it. India has also the India कर सकता है तो any state. So what happened? Sanctions can be on any of the states. Can or वो तो it completely depends on your country. Now coming to the second aspect, the executive check on the legislature. after a bill is passed by the US Congress, it is presented to the President for his assent, who can give his assent who can give his assent or can return the bill with his remark to the House in which the bill was introduced. This is known as the veto power of the President. So, in case of America, basically, if a bill is passed, the President can sign it or he can return the bill with his remarks that why he is not signing the bill. And after the bill is so returned, if both the houses of the US Congress pass the bill by two-third majority, two-third in this house, two-third in this house, which is a very difficult proposition, then the President, even though he will not sign the bill will become a law. But it is very difficult. It has never happened that a bill which is rejected by the President, it has been passed by both the houses by two-third majority here and two-third majority here. Because the President, his own partymen may be there in the House of Representatives as well as in the Senate. So it is a difficult proposition. That is why we say that the American President has got a veto power. Veto power means he cannot sign a bill. So this is the executive check on the legislature. Then the executive has no check on the judiciary. If the judges are appointed, they can be removed by the process of impeachment. Then the judicial check on the legislature and executive. The judiciary can review a law made by the legislature as well as a decision of the executive and can declare it as null and void if it is inconsistent with any of the provisions of the Constitution or a law. This is known as the concept of judicial review. This judicial review is present in our country also. You see, our parliament makes a law, it is challenged in the Supreme Court, and the Supreme Court can declare it as null and void. For example, the electoral bond scheme was passed by the parliament. Last time तुम लोगों को मैंने इलेक्शंस पढ़ाया होगा तो पढ़ा भी दिया होगा. So, and obviously there was a bit of controversy there. It was challenged in the Supreme Court, and the Supreme Court declared the law as null and void. So, in case of India also, we have got this concept of judicial review. It is the same as that of American system. So, you see that there is always a check and balance, because in democracy, if only separation of powers is there and this checks and balance is missing, democracy may not work well. That is why there has to be separation of powers along with the doctrine of checks and balance. This was the carry forward of the last class. Now, we discussed the parliamentary system, presidential system. Then, in relation to that, we discussed the concept of separation of powers with checks and balance. Now, in some of the countries of the world, like France, Russia, Sri Lanka, we have got a system which is a combination of both the parliamentary system as well as the presidential system. That is known as quasi-presidential system. In brief, I will tell you about that system also. Quasi-presidential system is a blend of the parliamentary and presidential system. Then the question arises that if it is a blend of both the parliamentary system and presidential system, why it is not termed as quasi-parliamentary? As it is more closer to the presidential system than the parliamentary system, It is termed as quasi-presidential and not quasi-parliamentary. So, such a system basically exists in France, Russia, Sri Lanka, and some other countries. Now, how this system basically works? I will tell you the French case because France is the role model of a quasi-presidential system. The French case. See, in France, the French president is directly elected by the people. When we say direct election, in fact, American president is elected through an electoral college. Now the elections are in process, so the procedure has started. But if we talk about the election of the French president, in France, the system is somewhat different from the American system. In France, a person, in order to get elected as the president, he needs to get a majority of the votes polled in the elections. Majority means more than 50% of the votes. In a multi-cornered contest, if there are two candidates, obviously one will get the majority, other one will not get the majority. But if it is a multi-cornered contest, then the chances are that the votes can be distributed and a candidate may not get majority. So in case of a candidate, any candidate not getting a majority in the presidential elections, then re-election takes place among the first top two candidates. Among the first top two candidates. It is known as runoff. It is known as runoff. So re-election takes place. And obviously in the re-election, the candidate who will be getting, one candidate will definitely get the majority. So in one of the main examination, this was a question, that is the French president's election to be compared with the election of the Indian president. Why? It is not that randomly the UPSC asks questions. In that year, 3 presidential elections had taken place across the globe. One, the election of the Indian president, then the election of the American president, and then the French president. Everyone who prepares in the UPSC examination, most of the students, they have a perception that they are the question setters. कि सर क्वेश्चन तो ऐसे आता है, आप देखो, हाँ सर ऐसे क्वेश्चन आता है, सर आप तो ऐसे नहीं पढ़ा रहे हो, तुम्हें ही पता, तुम ही पढ़ लेते. So basically this is, yes, this is the perception among the students, that they feel that they have the idea of the question in the examination. So in that year also I had told my students that 3 elections are taking place. American president, Indian president will be important from the prelims as well as from the mains point of view. But people are going towards the American president. They follow the election of the American president, but they do not follow American president's election. And what had happened that year was that Macron had got elected in a runoff. In a runoff. So that was an important aspect. So how the current affairs is linked with the questions which are asked in the examination, that is more important. Because the examiners know that the students must be following only the American president's election. For them it is Trump, they know that they have got the other persons. But for the UPSC point of view, whether you know the concept of runoff or not, so that was also a current affairs question. Random questions are not asked by the UPSC. That is why in that year, the question on French president's election was asked along with the Indian president's election, because runoff had taken place. None of the candidates had got majority in the first round. So such type of questions may be asked in the examination. So the year in which you will be appearing in the examinations, if the elections are going on for an important country, the president's election, obviously you need to follow that. What is the process for the elections? So he is elected directly by the people, and he appoints a person of his choice as the prime minister. These are the features of presidential system. Then the other ministers are appointed by the president in consultation with the prime minister. This is a feature of parliamentary system. Then the ministers not to be the members of the legislature This is the feature of presidential system. Then though the ministers are not the members of the legislatures, they take part in the proceedings of the National Assembly. National Assembly is the lower house. Like our Lok Sabha. Lower house, and the Council of Ministers is responsible to it. Responsible to it. It is a feature of parliamentary system. So you see, it is a blend of both the parliamentary system and presidential system. Now here, the most important aspect is that the last one that we had discussed, that is, the ministers will not be the members of the legislature, just as in the presidential system that we had discussed in the last class. But here the ministers will take part in the discussions, debates in the house, in the lower house, that is in the National Assembly. National Assembly is the popular house. The members are directly elected by the people, just as our Lok Sabha members. And the Council of Ministers, headed by the Prime Minister, is responsible to them. So we had discussed the concept of responsibility, that if a no confidence motion is passed in the lower house, then the Council of Ministers will no longer be there. In case of India, that political party remains in power which has got the majority in the Lok Sabha. If a no confidence motion is passed against the Prime Minister or against the Council of Ministers, the government will no longer be there. So the same thing. So even though the ministers are not the members of the legislature, but they will be taking part in the proceedings of the lower house, and they can be removed by the National Assembly. Now, it is a challenge for sometimes for the French president, whom to appoint as the Prime Minister, because the Prime Minister must have the support of the National Assembly. Otherwise, the National Assembly will pass a resolution and the Council of Ministers headed by the Prime Minister will no longer be there. And it is not necessary that always the President's political party will have majority in the National Assembly. So, in France, sometimes we have seen cohabitation. Cohabitation, that is, the president and the PM from different political parties. Now, sometimes a question is asked by the students that then how this system works. If the president is from the one party, prime minister from another political party, you see in France, what happens is that all the powers are vested in the French president. And if the French president wishes, he can delegate the powers to the prime minister and he can take rest, or he can assume all the powers and he can ask the prime minister to assist him. It completely depends on the president. So, even if the prime minister is from the opposition political party, it hardly matters in France. So, basically, this is how the quasi-presidential system works. I said France is a role model because Russia I don't consider as a role model. The same system prevails in Russia also. But we have seen only one man rule since we have got an understanding of the things. So, only one name we have been hearing. So, this is the basic idea that I wanted to give you. Now, the advantages with the presidential system is that there is quick decision making, and at the time of emergency situations, we can take the decisions can be taken really quickly. In a parliamentary system, first of all, the Council of Ministers will take a decision, then it will be communicated to the president will sign it, and then the law will come into force or the decision will be implemented. But on the other hand, when we talk about a parliamentary system, it has got advantages, and in a parliamentary system, the decision is taken by consensus, that is by the Council of Ministers. So even the people from different parts, that is the ministers may be from different parts, so there will be representation. And in a diverse country like India, parliamentary system may be suitable. So this was the carry forward of the last class: parliamentary system, presidential system, doctrine of separation of powers, checks and balances, and then finally the quasi-presidential system. Now coming to another feature of the Indian Constitution. So two features we had discussed. One was that India is having a written constitution. We had discussed unwritten constitution also, and then we discussed that India is having a parliamentary system, and therein we discussed these aspects also. फेडरल सिस्टम अभी बताया नहीं है ना? नहीं, फेडरल सिस्टम तो अलग होता है ना? हाँ? Now, coming to the next aspect, that will be another feature of the Indian Constitution. It has been drawn from various sources. The Indian Constitution has been drawn from various sources. Now here also, when we talk about the Indian Constitution, generally it is a criticism of the Indian Constitution, people feel, and some of the writers or the scholars have used the term bag of borrowing for the Indian Constitution. But you see that in India, you read textbooks, you don't read genuine books. बहुत रेयर होगा जो कि टेक्स्ट बुक्स मतलब जेन्युइन बुक्स लोग पढ़ते होंगे. वी रीड बुक, जनरली वी रीड द टेक्स्ट, भाई कहीं से कोई छाप दिया, इंडिया का राइटर है, लिख दिया. सम ऑफ द वेस्टर्न राइटर्स, they have used the nomenclature that Indian Constitution is a bag of borrowing. Basically, एज ए स्टूडेंट ऑफ और हम लोग भी बोलते हैं, उसके बाद देखा देखी इंडियन ऑथर्स ने क्या किया, वो भी लिख दिया बैग ऑफ बोरोइंग. हम भी बोलते सर इंडियन कॉन्स्टिट्यूशन बैग ऑफ बोरोइंग, मतलब विदाउट अप्लाइंग एनी सेंस. नाउ यू सी दैट देयर आर टू थिंग्स. नो कॉन्स्टिट्यूशन इन द वर्ल्ड कैन क्लेम ओरिजिनलिटी. इवन द फर्स्ट रिटन कॉन्स्टिट्यूशन ऑफ द मॉडर्न टाइम्स, that is the American Constitution, cannot claim originality. That is the American Constitution. ये नहीं कि the members of the Philadelphia Convention, they were sitting, the ideas were coming in their mind and they were writing. It's not like that. And basically, the ideas must have been taken from the political philosophers, political scientists. It is not that how the American president will be elected. The idea was there in their mind. They were not political scientists. They were not political philosophers. So, even that constitution cannot claim originality. Second, constitution is not the patent of any country. That you write the constitution and you write see and copyright. It's not like that. Basically, it completely depends on the situation of that country. If the same situations are there in your country, you can also have those provisions. And Dr. Ambedkar had clearly written at that point of time, he had said also that when we are writing this constitution, nothing can be original. Because we are writing the constitution at that point of time. We are writing the constitution in 1946, 47, 48. So, mainly all the countries had written their constitution except the post-colonial countries which had got independence after the Second World War. So, nothing original was left to us. So, it was admitted by Dr. B.R. Ambedkar himself in the Constituent Assembly that nothing can be original. So, basically, when we talk about the word borrowed, there is another aspect related to it. If you borrow something, you will have to return it. You will have to return it. So, if you say, oh, we have borrowed this aspect from America. Okay. If tomorrow United States of America will say, you return it to us, how you will feel? How you will feel? You will feel bad. So, basically, when we use a nomenclature, it is not that we should be the followers. We should be, he said, my teacher has said this. Why your teacher said this? There must be some logic behind it. So, bag of borrowings may not be the suitable term. But from the examination point of view, there can be a question in the main examination. You can write the question, how far it is justified, to term the Indian Constitution as a bag of borrowings. As a bag of borrowings. Generally, if you ask this question to the students, what they will do is that वो जो किताब में लिखा हुआ है ना, we have taken this from this, वो पूरा list they will write. From US we have taken this, from Weimar Constitution of Germany we have taken this, and then after that they will write, thus Indian Constitution is a bag of borrowings. That is why the students, they get lesser marks in the Indian polity and governance section, because they feel that they can write anything. They get bad marks in paper 1 of PSIR, especially section B. So, the Indian government politics, we can write anything. We have done a research, we can write anything. Then in Indian administration paper of public administration, they get lesser marks. So, they concentrate only on theory, thought, wo sochte bas yahi hai. But they fumble when they need to write answers on such questions. Here you say that the questions have to be analyzed. Here the question is how far, to some extent, to a large extent. Now you see, before I will tell you a model answer, certain things that we need to explain. Constitution is just like a shirt. Suppose if I like a shirt that you people are wearing, one of you are wearing, I will ask you that which is the brand. You will say, sir, this is the brand. Then I will say, okay, from where you have purchased it? You will say, sir, from here I have purchased it. Then I will go to the shop, I will purchase the same shirt. But what will be different? The size will be different. If I will be wearing the size of the shirt that you are wearing, then that will not fit into my body. So I will change the size of the shirt. Similarly, if your country is following a certain provision, if it suits my country also, even with modifications, according to the needs of the people and the circumstances prevailing in the country, we can adopt it. So, for example, you see, our constitution makers, they freely went through all the constitutions which were prevalent at that point of time, and they took not the best things. ये गलत लोग बोलते हैं अरे they took the best thing. No, they took different aspects from different constitutions, but they gave them an Indian color. They gave them an Indian color. And you see, I'll give you an example. First of all, if we talk about this concept of federalism, federalism means two sets of government, one at the central level, other one at the state level. That is a federal system. In the books, you will find in most of the books it is written, we have taken federalism from America. We have taken federalism from America. That may be a half truth. That may be half truth. The idea of federalism, idea that there should be two sets of government, it was there in the Government of India Act 1935. It was there in the Government of India Act 1935. Because you see that the Government of India Act 1935, it provided for elections for the provincial assemblies. It means that there was a central government and there were provincial governments also, and the governments were also formed. So the idea that there should be two sets of government was there in the Government of India Act 1935. We have not taken it from America. The idea was there. The Indians were knowing this system, that we have got the British authority and we have got the provinces. Then we did not exactly copied the American system. Our country is a diverse country. There is diversity. From Kashmir to Kanyakumari, the whole country is divided in the name of religion, language, caste, regional aspirations are there. And basically, if we would have followed the American model, the fear of the disintegration of the country would have been more. They have got dual constitutions, dual citizenship. In India, we have single constitution with single citizenship. So, our constitution makers started searching for a model that in a diverse country, what type of federalism will be good. Then they came across the Canadian Constitution. And the Canadian Constitution provides for a federal system with a strong central government, because where there is diversity, you require a very strong central government. Otherwise, the divisive forces will be very much active in the country. So, keeping in view the need of India, we adopted the concept of a federation with a strong center. And this we took from the Canadian Constitution. अभी मैं आपको लिखवा भी दूंगा. I will make you to write it. Canadian Constitution. Our constitution makers did not stop here. They thought of another thing, that there may occur the disputes between the states with respect to river water or some other issues. No doubt in a federal country, there will be a federal court to arbiter the disputes. But in an amicable way, without going to the court, if the problem can be solved. They started searching for a model, that if any country had got such model, and they came across the Australian Constitution, which provides for the concept of cooperative federalism. And we incorporated the provisions with respect to the cooperative federalism. So you cannot exactly say that the federal model, the federal system, federalism in India that we have today, it is exactly the replica of this country or that country. This is the beauty of the Indian Constitution. Not only this, other provisions are also there. For example, Article 14. Article 14 provides for equality before law and equal protection of laws. Equal protection of laws. Equality before law has been taken from the UK Constitution. Equal protection of laws has been taken from US Constitution. Now you see that equality before law means we all are equal in the eyes of law. That is the concept of a blindfolded lady carrying away. That is, I know no one, and on the basis of the evidences, I will give the judgment. Whether a person is a government official or a common man, the laws are equal to all. That is equality before law. But if you have got only equality before law, complete justice cannot be done. Complete justice cannot be done. Because suppose if a murder has been committed, two persons have committed two different murders, one to protect himself and the other person is a hardcore criminal. He has got a criminal background. Now, it is not that here you see the circumstances are different. One person has done a murder, he has killed someone protecting the other members of the society or in self-defense. The other person is having a criminal background and he has murdered someone deliberately. He may have taken money also. But if you give death sentence to both, it will be injustice to one. So that is why even if there is equality before law, complete justice may not be given. So we incorporated another aspect in the Constitution, that is equal protection of laws, which have taken from the US Constitution. That is equality under equal circumstances. Equality under equal circumstances. That is, likes to be treated alike. If the circumstances are equal, then you both will be treated equally. If the circumstances are not equal, you will not be treated equally. Now you see the beauty of the Indian Constitution. That is why we have got a lot of respect for Dr. B.R. Ambedkar, and really he has drafted one of the finest constitutions of the world. Two different aspects taken from two different constitutions, and they have been given an Indian color. Many more examples are there to substantiate this point. So basically we have taken the things from the other countries, but yes, we have given them an Indian color. This is the first dimension that we need to carry in such type of questions. I'll tell you a model answer. You can write it also, because for the first time you are preparing. So you need to have an idea how to write an answer also. You can write it. No constitution in the world can claim originality. Can claim originality. Full stop. The ideas must be taken from the ideas must be taken from the political philosophers and the political scientists and the political scientists. Full stop. Our constitution makers went through the various constitutions and they took various provisions from them but gave them an Indian color according to the needs of the people and the circumstances prevailing in the country Full stop. For example, the idea of federalism was taken from the Government of India Act 1935, full stop, keeping in view the diversity of Indian society, comma, the idea of a federation with a strong center was taken from the Canadian Constitution and for the amicable solution of disputes that may arise between the center and the states, amicable solution of disputes that may arise between the center and the states or between the states themselves comma, the idea of cooperative federalism the idea of cooperative federalism was taken from the Australian Constitution. Was taken from the Australian Constitution. So this is the first aspect, that we have taken the things, but we have given them an Indian color. But coming, the answers have to be multi-dimensional. Then basically you will get more marks. ये नहीं कि इसी में you will get some more examples and then your 150 words will be over. So the answers have to be multi-dimensional in the main examination. Now in the second aspect, we will be talking about the provisions which we have taken from other countries and we have put it in our constitution without any change. Because there are some provisions of the constitution which have been taken from the other countries and we have incorporated them without any change. So we need to mention, the question क्या है? How far? है ना? How far? So you will have to analyze the things. So in the next paragraph you can write, some of the provisions of the Indian Constitution, some of the provisions of the Indian Constitution are exactly the same as the other constitutions. That is, they have been incorporated without any change. For example, Article 301 freedom of interstate trade commerce and intercourse. Freedom of interstate trade, commerce and intercourse, which has been taken from the Australian Constitution. Trade means buying and selling of goods. Commerce also means the same thing, buying and selling of goods. But what is the difference between trade and commerce is that in trade, profit making is more important and in commerce, transaction is more important. ये बोलते commercial activities have started. So transaction is more important. Then intercourse means going from one place to another place for cultural interaction. समागम बोलते हैं, for cultural interaction. So this aspect, that is freedom of interstate trade, commerce and intercourse. It is not your personal freedom. It is interstate trade, commerce and intercourse. It shall be free. This aspect we have taken from Australian Constitution. I will be discussing these articles in detail also in the coming classes. Abhi to just in different context I am telling you. Now after writing this aspect, that some of the aspects we have taken from other countries and we have, that is exactly the same. Some of the aspects are our own. We have not taken it from any other country. Can you name some provisions that we have not taken from any other country which are our own? Fundamental duties were there in the Japanese constitution and the erstwhile constitution of USSR, in the Chinese constitution also. Panchayats, panchayats, and abolition of untouchability, because untouchability is a typical practice of the Hindu social order. It is not present anywhere. So if we are abolishing it, it is our own. So some of the provisions, they are our own. So in the next paragraph you can write, some of the provisions of the Indian Constitution are our own, That is, we have not taken it, or we have not taken them from any other country. We have not taken them from any other country. Like abolition of untouchability, then panchayat, then Indian brand of secularism, etc. In the topic of preamble that will starting from tomorrow, I will be telling you the concept of secularism, how our secularism is different from the other secularism, why the Indian secularism is known as positive secularism. So in our country, we have adopted a brand of secularism which is different from the Western concept of secularism. So here you see that some of the provisions are indigenous, that is, they're our own. Now every answer has to be concluded. There has to be a proper conclusion of the answers, because what an administrator does, an administrator concludes the meeting, यानी कि बीच में उठ के चल जाता है. So yes, so you'll have to conclude in accordance with the question which has been asked. How we need to write a conclusion, इसी का एग्जाम्पल देके मैं आपको बता देता हूं. In the next paragraph you can write, based on the above analysis, it can be concluded or दोनों, you can use any language, or we may conclude that the Indian Constitution may be termed as a bag of borrowings, to some extent. Full stop. It may also be said that it is a patchwork but a very beautiful patchwork. Beautiful patchwork. This statement was given by पॉलिटिकल साइंटिस्ट, हिज नेम वाज प्रोफेसर चेतकर झा. आप लोगों ने तो उनकी किताब भी नहीं सुनी होगी. तो हाँ, आप लोग तो वो लक्ष्मीकांत सुनते हो ना. सो it was his original words. So he had used this term that the Indian constitution may be termed as a patchwork, but it is a very beautiful patchwork. Now you see, what we have written, it hardly matters for it, but how we need to write an answer, that was my motive. When you conclude, the first thing that basically you may have noted, that even in the simple questions, we can make the answers multi-dimensional. This is the first thing that you need to develop in yourself. That is how to write multi-dimensional answers. It was a very dull question, very dull question. But yes, we will have to develop an approach. Then, secondly, when you conclude, our conclusion should be not arrogant. Even if the question says, do you say, do you agree? Never say, I say this, I agree this, I agree. Never. The simple reason is that an administrator cannot be arrogant. I. This word itself seems to be arrogant. Even if it is I, you should say we. We. And if you have written some facts as per the needs of the examination, you need to conclude that on the basis of the above facts, because you have written the facts, on the basis of the above facts, you have analyzed the things based on the above analysis. If the analysis is based on judicial interpretations, based on the judicial interpretations, so you will have to develop such type of aptitude, and then you should say we may conclude, we may, or it can be concluded. Now when we use the word we may, it reflects your administrative aptitude. Basically, this test is all only to select a good administrator for this country. ये नहीं समझना कि आपको नौकरी देने के लिए एग्जामिनेशन हो रहा, भूल जाओ. It is not a charitable thing that that is the taxpayers' money that will be given to us as a salary. So it is not a charity that is to be done. Arey nahi, job has to be given. It's not like that. We are going to select an administrator for this country. He should have an administrative aptitude. And an administrator is a team person. And suppose if the members of the panchayats have come who are of the age of your grandparents, and if they come to you and after 1 or 2 hours with discussion with them, you say that okay, this is the decision. They may feel annoyed also. He or she is the age of my grandson and he is very rude. But after hearing them, then if you say politely that gentlemen, for the last 30 minutes we have been discussing this aspect and I feel that we have come to this conclusion. We have come to this conclusion. A more polite way of putting your views. An administrator should not be impolite. Abhi bhi, you may have, I don't know, that whether you go by the current things which are going on in the country or not. The Prime Minister's initiative with respect to the administrative reforms, Mission Karma Yogi has been launched few years back. And the vision of a Karma Yogi bureaucrat, Karma Yogi civil servant, is that he should be polite. He should be polite. Usme 6-7 aspects are there. The UPSC or the government looks into those aspects. So that should be reflected in your answer. What you write is not more important. That is how you present your view is more important. Now, when you use this word, we may conclude what you have done. You have made the examiner a party to the answer. You have made the examiner a party to the answer. Now, if I say, oh, I say this, the teacher had said this. But if I say that we have come to this conclusion, no, yes, the teacher discussed with us, and then we had come to this conclusion. So, from the very beginning, you will have to develop this administrative aptitude, and that will be reflected in your answers also. So, it is not only about knowing certain facts, it is about presenting also that matters a lot. So, that is why I made you to write this answer, to show you that how you should proceed, even how the easy answers have to be written. So, kabhi bhi conclusion likhna na, you should write like this: we may conclude, it can be concluded. A soft person, that should be the, theek hai. While dealing with law and order, you should be hard from inside, but yes, you should be soft while dealing with the people. Then, so ye to ho gaya mains ka aspect. So, in every topic, there is a aspect of main examination as well as the prelims examination. Now, in the prelims examination, the questions can be on the sources of the Indian Constitution. The mere facts are there. UPSC is not very much fond of asking the questions. He match the following from where we have taken. No. If you will be appearing in your state public service commission examinations, then you can just have a glance that from where we have taken what aspect, and if a question is asked, you can take it. But from the UPSC point of view, no need. You should have an idea regarding it. And the study material that has been provided to you by our institution, obviously it will have the list also that from where we have taken what. So there is no need of dictating it in the class that we have taken this aspect from here, this aspect from there. Now, ye to one question that you need to prepare from the mains point of view. Another question you need to prepare from the mains point of view, likh lena. The provisions that have been taken from the Government of India Act, 1935. So your emphasis from the mains point of view will also be on the what we have taken from the Government of India Act 1935, because such questions have been asked in the main examination twice. That is in the recent past. That is, the Indian Constitution is a reflection of the Government of India Act 1935. So basically, what aspects we have taken from the Government of India Act 1935, that you need to emphasize. So ये दो questions लेकर के आप मेंस में आराम से जा सकते हो. Prelims के लिए, if you wish, you can have a glance that what we have taken from where. This was the third aspect, the feature of the Indian Constitution that we were discussing. It has been drawn from various sources. Now coming to another feature of the Indian Constitution. It is a flexible constitution with few rigid provisions. Now, here also, first of all, coming to the basic things. It is a flexible constitution with few rigid provisions. Two words we have written, flexible and rigid. What is the basis of this differentiation? One sentence you can write here. Based on the process of amendment of the Constitution, the constitutions have been classified as unitary and federal. Unitary and federal. Based on the process of amendment. That is how the constitution is amended. Amendment means changed. How the constitution will be changed. Based on that, we have got the constitution as flexible and rigid. As flexible and rigid. Now, one by one, I'll tell you, when we say flexible constitution, a flexible constitution is that constitution which can be amended easily. You can write here, a flexible constitution is that constitution which can be amended easily that is only by the central legislature. Only by the central legislature. Means if the central legislature will pass the bill, the constitution will be amended after being signed by the head of the state. Now, when we talk about a rigid constitution means the central legislature plus the ratification by the states also. That is, we can say the rigid constitution. You can note it. A rigid constitution, जाना है चले जाओ. A rigid constitution does not mean that the provisions cannot be amended, does not mean that the provisions cannot be amended, but the process of amendment is a complex one. Full stop. After a constitutional amendment bill is passed by the central legislature, it has to be ratified by specified number of state legislatures also. The example of flexible constitution, Chinese constitution, then rigid constitution, the US constitution. So what is rigidity about the US constitution is that after a constitutional amendment bill will be passed by both the houses of the US Congress, then it has to be ratified by 3/4 of the state legislatures. Okay, you can write it here. Yeah, listen. After a constitutional amendment bill, is passed by the houses of the US Congress, it has to be ratified by 3/4 of the state legislatures. 3/4 of the state legislatures. How many states are there in America? 50 states are there. So what will be the 3/4 of 50? 37 होगा. देखो जरा एक बार करके. टी सेट देना है तुम लोगों को. हाँ 35 ऐसे ही बोलोगे. इंजीनियरिंग की हो तो फिर करके देखो. ये 37 कुछ आएगा. मैंने तो मैथ्स कभी पास ही नहीं किया, मतलब 10th के बाद तो मैं छोड़ ही दिया मैथ्स. साइंस पढ़ा लेकिन पॉलिटिकल साइंस पढ़ा. हाँ, आई रेड पॉलिटिकल साइंस. आई रेड साइंस बट आई रेड पॉलिटिकल साइंस. हाँ बताओ कितना है? तो 38 होगा ना. स्टेट को आधा टुकड़ा तो करोगे नहीं. It will be 38. So you say in the United States of America, if the constitution is to be amended, then both the houses of the US Congress need to pass the constitutional amendment bill. After that, it has to be ratified by 38 of the states legislatures. So getting the support of 38 state legislatures is not an easy proposition. That is why we have got very lesser number of amendments that have taken place in the US Constitution. ये तो हुआ US Constitution is an example of a rigid constitution. Now when we talk about India, in India, most of the provisions can be amended by the parliament, the special majority that we had discussed in the last class. But some of the provisions of the Indian Constitution, they, after getting passed by the parliament by special majority, they need ratification by 50% of the state legislatures. So in our constitution also we have got some rigid provisions. So here you can write as note, in case of India, there are some provisions of the constitution which after being amended by the parliament, need ratification need ratification by at least 50% 50% or half of the state legislatures Now, one more thing that you need to understand here is that wherever the word state legislatures have been mentioned, it will include the legislatures of Puducherry as well as Delhi also. Clear? So here it is. So how many legislatures will we have? 28 states are there. 2 union territories are there which are having their own assemblies. So out of 30, if 15 of the legislatures they approve or ratify the constitutional amendment bill, then the constitution will be amended. So in case of India, they are known as rigid provisions. ये तो हुआ your basics. So in case of India, which provisions can be termed as rigid provisions? Parliament plus 50% of the state legislature. In Parliament, a special majority will be required, and in the state assemblies, simple majority will be required. Now coming to the second part, that what are the rigid provisions of the Constitution? Means which provisions of the Constitution they need to be read after being passed by the Parliament, they need to be ratified or approved by 50% of the state legislatures. Now here we are going to discuss the provisions which after being amended by the Parliament, they have to be ratified by 50% of the state legislature. First, Articles 54-55 dealing with election of the president, then Articles 73 and 162 the extent of the executive power of the Union and the states, then part 4 of chapter 4 of part 5 chapter 4 of part 5 dealing with union judiciary and chapter 5 of part 6 dealing with state judiciary that is the high courts and the subordinate courts. Then Article 241, high courts for the union territories. Then Chapter 1 of Part 11 dealing with the center state relations, the center state relations. Then representation of the state in the parliament. Then any list under Schedule 7. Then Article 279A, GST Council, and then Article 368, process of amendment of the Constitution. So these are the provisions of the Constitution which can be amended first by the Parliament. A bill will be passed, and after that they will be referred to the states, and after 50% of the states will ratify, then only the President will sign the constitutional amendment bill. Then one more sentence you can write here: rest all the provisions of the Indian Constitution, all the provisions of the Indian Constitution are flexible in nature, that is, they can be amended only by the Parliament, Now you see that out of nearly 485 or 490 articles of the Constitution, only these many are rigid in nature. Rest all are flexible. So you cannot say that our Constitution is partly rigid, partly flexible. Partly nahi hai. It is a flexible Constitution. It is more flexible than rigid. No doubt there is a combination, but it is more flexible than rigid. Now coming to the second part. द वाई पार्ट। ये तो हो गया व्हाट, प्रीलिम्स के लिए इंपॉर्टेंट है। दिस इज इंपॉर्टेंट फ्रॉम द प्रीलिम्स पॉइंट ऑफ व्यू, दैट विच ऑफ द provisions of the constitution are flexible in nature, 1 and 2, 2 and 3, 3 and 4. But now if someone will ask you that why some of the provisions of the Indian constitution, they have been made rigid in nature. You see here, fundamental rights are also not rigid. They can be amended only by the parliament. Now we will be using a common sense here. If we analyze these provisions, most of the provisions are related to the center-state relations. So wherever the chances are that the center will dominate, the center will cut short the powers of the state governments, those provisions have been made rigid in nature. For example, if you talk about Articles 54, 55, Articles 54 and 55 deal with the election of the president. In the election of the president, the elected MPs as well as the MLAs, they take part. Now, suppose if this is a flexible provision, if it is not there in this list, and suppose a political party comes to power at the center, and at the center, in the Lok Sabha and the Rajya Sabha, it has got MPs, large number of MPs, but in most of the states, the MLAs belong to the other political parties. So, but if it is a rigid provision, and then the political party will say, our presidential candidate will be defeated because we have got lesser number of MLAs in comparison, and our candidate may be defeated. Then what they can do? They can amend this article number 54, that only MPs will take part in the election of the president. Power of the states gone. So you can change it, but only with the consent of the 50% of the states, because here the interest of the states is involved. And then Article 73, what will be the extent of the power of the union executive? You can pass a bill that the power of the union executive can be extended, or the power of the state executive can be extended. Get it ratified by 50% of the state legislatures. If they say yes, you can do that. And then the provisions related to union judiciary, the state judiciary, not a single article related to the Supreme Court, High Courts or the subordinate courts can be altered without the consent of the 50% of the states. Why? First logic, Supreme Court is the federal court. Whenever there is a dispute between the center and the states, it is referred to the Supreme Court. So, the states are also affected, because if the Supreme Court's powers are curtailed or it is extended, obviously, or any article is to be changed, the process for the appointment of the judges or the removal of the judges, jurisdiction of the Supreme Court, if anything has to be changed, then ratification by 50% of the states will be required. Logic here, to safeguard the independence and impartiality of the judiciary. And the next points also, the logic will be the same. Chapter 1 of Part 11, the center-state relations. Here also the whole chapter, it is a rigid provision. Then representation of the states in the parliament. You see that we have got fixed number of members from each state in the Lok Sabha and in the Rajya Sabha. Here also, no changes can be made by the parliament alone. Here, what is the logic? The logic here is also the same. Suppose if we have got the Bharatiya Janata Party, which is in power, that is the NDA. And the NDA, from where it gets the maximum number of seats? From which states the NDA gets the maximum number of seats? UP, then Madhya Pradesh, Maharashtra, Rajasthan, Gujarat, Haryana. These are the states. Bihar. These are the states from where the NDA gets the maximum number of seats. Suppose if the NDA comes to power and feels, oh, Tamil Nadu, Kerala, they never vote for us. What we can do is that increase 2 seats of from UP, Madhya Pradesh, Chhattisgarh, Rajasthan, because they vote for us, 2 seats each, and cut short 2 to 1 seats from Kerala, 1 from Tamil Nadu. Then the states who are not voting for us, their seats should be curtailed. That can be done. But that is why, to stop a political party from acting like this, to protect the interest of the states, here what we have seen is that these aspects have also been made rigid in nature. You can change it, but with the consent of the states. Then any list under Schedule 7. In the 7th schedule, we have got the union list, state list, and the concurrent list. Here also, no addition or deletion can be made. No addition or deletion without the consent of the states. Here also the logic is the same. Here what the central government can do? Add more subjects in the union list or the concurrent list. Then reduce the number of seats which are there in the state, the subjects which are there in the state list. That can be done. Here also protection of the interest of the state. And then GST Council. This GST Council consists of the Union Finance Minister as the chairperson, and it also consists of the finance ministers of all the states, and all the decisions regarding GST, like GST laws, then GST rates, special provisions for some of the states, all this is taken by the GST Council. No changes can be made in Article 279A, where the composition of the GST Council, the functions of the GST Council has been mentioned. No changes can be made here without the consent of the 50% of the states, because GST Council takes decision for the states also. And process of amendment of the Constitution, Article 368. All the aspects that we have written here, they are mentioned in Article 368. Article 368 deals with the process of amendment, that how the Constitution will be amended. And in Article 368 it is mentioned that these provisions of the Constitution, after being amended by the Parliament by special majority, they require the ratification by half of the states. The list is there in Article 368. No doubt the explanation part is not there. Only articles have been written down. Article 54, 55, like this, they have written in the parts. Explanation I have written it for your understanding, so that you will be able to understand the things. So Article 368 has included itself also in the list that I am also rigid. Why? What can be the logic? Kyun? Very good. Because if Article 368 is a flexible provision, then amend Article 368 only, that all the provisions of the Constitution can be amended only by the Parliament. Your whole Constitution will become flexible. So that is why this article is also rigid. And if you want to amend the process of amendment, that is Article 368, the ratification by 50% of the states will be required. So this is the logic. So you can write as note, NOTE. An analysis of the rigid provisions, of the constitution shows that the provisions which are related to center state relations, comma, which aims to protect the interests of the states, and which aims to safeguard the independence of judiciary, have been made rigid in nature. The thing should be there in your notebook, so that when you revise the things, क्या होता है ना क्लास में sometimes we are here and there कुछ बोल भी जाते हैं ना, तो when you revise the things should be अच्छा, this is the logic that the teacher had given, you will be able to correlate the lectures with what we have written. इसीलिए ना कॉपी में भी everything has to be there. This is the point that we need to look into. हाँ, you see that the high courts for the union territories, they come under the jurisdiction of the states, except Delhi and the Jammu and Kashmir. They have got separate high courts, but for all other high courts, the jurisdiction is to the nearest state. Suppose if you want to create a new high court, or if you want to have some provisions with respect to the high courts, then it will be affecting the states also, because their jurisdiction can be cut short. For example, the Madras High Court has got jurisdiction over Puducherry also. We have seen that the jurisdiction of the Kolkata High Court is over Andaman and Nicobar Islands. Kerala High Court has got jurisdiction over Lakshadweep. So, Punjab and Haryana High Court have got jurisdiction over Chandigarh. So, here what we say, that the states will be affected if we will make some modifications, because revenue comes to the state through the high courts also. So, the states will be affected if you will be going for the changes in Article 241. That is why the consent of the states will be required here, 50% of the states. If they say, okay, you make necessary changes, you can make necessary changes. ठीक है, ये logic. हाँ, it will be required. Now, basically here when we talk about Article 241, it talks about the provisions. For example, if you need to create a separate high court for a union territory, for that it may not be required. Independently it may not be required, because for article it is a union territory. The other states will not be affected by that. That is. Now, so this is important from the prelims point of view, and you need to have a basic idea also. अब तो किसी से you can talk ना कि भाई why we have got rigid provisions in the constitution. Coming to the next important feature or the salient feature of the Indian Constitution, it is a federal system with strong unitary features. Here also you see two words, federal and unitary. This is also political system. It is also political system that we need to understand. One parliamentary system and presidential system, political systems, then unitary system and federal system. Now, what is the basis of this classification? You can write it here. Based on the division of powers between the center and the states, political systems have been classified as unitary and federal. Based on the division of powers between the central government and the state government. How the powers will be divided between the center and the states. So we have the unitary system and the federal system. Now in a unitary system, there is concentration of powers in the central government. There may be delegation of powers there may be delegation of powers. UK, France, China, these are some countries which are having unitary system. When we say federal system, in a federal system, there are dual governments. The central government and the state governments. And here, there is decentralization of powers. US, Canada, Switzerland, South Africa, Australia, Many countries are there which are having federal system. Now, those of you who have not understood it, I will tell you with the help of illustration also. Suppose this class is an example of a unitary system. And if I am the central government and you people are the state government, the unitary system does not mean that there will be no states. The states will be there. But the powers will be concentrated in the central government. So, constitutionally, all the powers will be concentrated in me, and if I wish, I can delegate some of the powers to you. That okay, these are my powers, but you use it in your state. You can collect taxes on these subjects. I can delegate the powers to you. This is, we can say, the first one, unitary system. The same type of system we can say is there in United Kingdom. In United Kingdom, they have got Scotland, Wales and Northern Ireland. These have got their assemblies also. Scotland has got assembly, Northern Ireland has got assembly, then Wales has also got assembly. But the power is concentrated in the central government at London. If the central government wishes to delegate the powers, okay, Scotland Legislative Assembly or Provincial Assembly can impose taxes on these subjects. You can collect taxes on these subjects. Okay, the power has been delegated. The power has been delegated to Wales. But if I wish, can take back the powers at any point of time. Because constitutionally, all the powers have been delegated to me. Then, now if this class is an example of a federal system, you people are the state government and if I am the central government, then what will be my powers, what will be your powers? There should be clear-cut demarcation or division. That is known as decentralization of powers. Powers will not be centralized in me. It will be decentralized. Powers will be given to you also. Powers of the union government, powers of the state government. This is, we can say, the federal system. Now, when we talk about India, here I have not written India. Now, what is the nature of the Indian state? So, this was the basic thing that we needed to know. What is the federal system? What is the unitary system? Here, if we talk about the nature of Indian state, the drafting committee it held that India was a federal system. Was a federal system. Whereas Professor K.C. Ware he had looked into the working of, he had analyzed the different provisions of the constitution, the working of the federalism, and he was of the opinion that India was quasi-federal. Now you see that a student like me will get confused. Why? Because the committee which had drafted the Constitution of India, it says that India is a federal system. On the other hand, a political scientist, Professor K.C. Ware, who had analyzed the different provisions of the Constitution, the working of the federal system, he says that India is quasi-federal. In social sciences, the views are not wrong. The facts can be wrong. The views are not wrong, but we will have to understand the context in which the views are given. So, we should not blindly accept what the drafting committee had said or what Professor K.C. Ware had said. For that, we will have to first understand a theoretical thing, that is, the essential conditions of a true federation. Essential conditions of a true federation. It is important from the prelims point of view. Means, what are the essential aspects that has to be there in a federal system? A written constitution, then supremacy of the constitution, rigid constitution, a bicameral legislature, division of powers, and an independent judiciary. Any other point, any other element or condition that will be there in your question paper should not be encircled by you. Take only these are, because the political scientists have held it that these are the features or the conditions of a true federation. So the theoretical questions, obviously we are not political scientists. गलती से पढ़ने लगे हैं तो ये we should not feel that yes we are the masters in political science. कि अपने मन से नहीं सर ऐसे तो नहीं होता है, कितने ही पढ़ लिए. यस हाँ, वो स्टूडेंट्स करते हैं और जो पीएसआई और ऑप्शनल तो थोड़ा ज्यादा करते हैं. हाँ, उनको तो लगता है कि बस वो सारा सच समझ गए हैं तुरंत, तो वो अपनी थियरी भी बनाने लगते हैं. they start making their own theories also. But it is not like that. In the question paper, if these 6 are there, you need to encircle them only. I'll tell you the logic also. First of all, why a written constitution? Because the powers of the center and the states have to be written down. That is feasible only when you have a written constitution. And the document where the powers have been written down, that should be the supreme law of the land. There should be no other document above that document, otherwise people will not follow it. And then, why rigid constitution? Otherwise it will become a plaything in the hands of the central government. As and when the central government feels comfortable, it can manipulate the provisions of the constitution for its own interests. That is why the third point, a rigid constitution. It should not be the monopoly of the parliament or the central legislature to amend the constitution. And then a bicameral legislature. Why? One house should represent the people directly and the other house should represent the states. And then there has to be clear-cut division of powers. These are the powers of the union government, these are the powers of the state government. And after that, an independent judiciary. Judiciary should not be biased towards the central government. And Why an independent judiciary? Because the judiciary in a federal system, especially one court, that is the federal court, it arbitrates the disputes that may arise between the center and the states or between the states themselves. अगर judiciary आपकी biased होगी, then justice will not be given to the states. These are the 6 important conditions of a true federation. India fulfills all the features of a true federation. You see, our constitution is a written one. Then it is the supreme law of the land. We just discussed that the provisions related to the center-state relations are rigid in nature. And then we have a bicameral legislature. The Rajya Sabha represents the states and the Lok Sabha represents the people. We have got division of powers. 3 lists are there: union list, state list and concurrent list. And then the Supreme Court is the arbiter of disputes that may arise between the center and the states or between the states themselves. That is why the drafting committee may have said that India is a federal system. This is the context. ठीक है, लिख लो इसको, फिर आगे बढ़ते हैं. India fulfills all the conditions of a true federation. Full stop. It has a written constitution. Which is supreme. Full stop. The provisions regarding the center-state relations, are rigid in nature. The provisions regarding the center-state relations are rigid in nature. There is a bicameral legislature at the center. The Lok Sabha consists of the directly elected representatives of the people, while the Rajya Sabha has the representatives of the states. Full stop. There is division of powers. Between the center and the states. On the basis of 3 lists. Given under Schedule 7. And the Supreme Court acts as the arbiter of disputes, arbiter, ARBITER, arbiter of disputes that may arise between the center and the states, or between the states themselves. So ये तो फर्स्ट लॉजिक हुआ, दैट व्हाई द ड्राफ्टिंग कमिटी. सो इसी तरह से ना, इफ वी नीड टू अंडरस्टैंड द थिंग्स प्रॉपरली, वी नीड टू अंडरस्टैंड द कॉन्टेक्स्ट. अभी हमने वी डिस्कस द कॉन्सेप्ट, तो कॉन्टेक्स्ट आपको समझ में आया, देन ओनली यू विल बी एबल टू अंडरस्टैंड, अच्छा व्हाई द ड्राफ्टिंग कमिटी हैड सेड दैट इंडिया इज ए फेडरल सिस्टम. नाउ कमिंग टू प्रोफेसर केसी वेयर्स व्यूज that India is quasi-federal. Quasi means semi-federal, not completely federal. Here not only Professor K.C. Ware, but some of the other Western writers, they have also used this nomenclature that India is a federal system with a strong unitary biasness. Such type of expressions have been used for India. Now here, the scholars who have used this expression, Professor K.C. Ware and others, quasi-federal, they have taken into consideration America as the role model of a federal system. कि भाई America is the role model of a federal system, and these aspects are there in the American system. These aspects are not there in India, so India is not a true federation. So they have done a comparison, and so from that angle we have to look into the things. America has got dual constitution. There is the Constitution of United States of America, and there is Constitution of each of the states. There is dual citizenship. A person is a citizen of America as well as the citizen of the state in which he is living. There are exclusive rights that he enjoys in that state, which is not there in India. In India, the states are at the mercy of the central government. If tomorrow the central government wishes, UP can be divided into two parts. Madhya Pradesh was divided into two parts. So you can do. The states have no voice in that. The consent of the state is not required. Not only this, if you analyze the three lists which are there, more number of subjects and more important subjects are there in the union list. In the concurrent list also, both can make laws, union government as well as state government. But if the central government as well as the state government make a law on the same subject, it is the union law or the central law that prevails. Then we have the office of the governor. Governor is appointed by the central government, but he is the executive head of the state government. And then we have got the officers of the All India services. How many services are there under All India services? 3. Which are they? Indian Administrative Service, Indian Police Service, and Indian Forest Service. Okay. Why these are termed as All India services? हाँ, तो ऑल ओवर इंडिया तो इनका भी है. इंडियन रेवेन्यू सर्विस वाले, तुम यू विल बी हियर टुडे एंड टुमारो यू विल बी देयर इन आंध्र प्रदेश. हाँ, ओके. और इनका अच्छा, ठीक है. हाँ, आप कुछ बोल रहे थे, यू आर सेइंग समथिंग. हाँ, बोलो. अच्छा, So think the officers of the All India services, that is the IAS and the IPS and Indian Forest Service, they are appointed by the union government, but they largely serve under the state governments. They can come on deputation to the center for some time, but throughout your life you will be termed as an IAS officer of the Kerala cadre, an IAS officer of Assam cadre, an IPS officer of West Bengal cadre. Throughout your life you will be termed. You can come to the center on deputation. Your transfer, your promotion, that will be decided by the concerned state government. Your salary will also be paid by the state government. But for the other civil services, you will be directly under the central government. You are in the railways or you are in the revenue services, Indian audit and account services, you will be under the direct command of the or control of the central government or the union government. Okay. So you see, this is also a distinctive feature, but you see that these are not negative aspects. We adopted it ourselves. Why? Keeping in view the diversity in the country, the center should be strong. Otherwise, there will be the states, the divisive forces in the states can become active. The states can go here and there. So that is why, because of these distinctive features, Professor K.C. Ware may have said that India was quasi-federal. ठीक है, लिख लो इसको, मैं लिख लूँ. In the next paragraph, you can write, but India has some distinctive features. But India has some distinctive features. Underline distinctive features. You can write in points. First, it has a single constitution. It has a single constitution with single citizenship. With single citizenship. Next, Article 3 authorizes the Parliament. Article 3 authorizes the Parliament to alter the area or boundary or to change the name of a state. Or to change the name of a state. Full stop. In other words, here only you write. In other words, the states are at the mercy of the union government. This will be discussing in detail when will be discussing part 1 of the constitution. क्योंकि इसके discussion के बाद we'll be discussing the preamble, and after preamble part 1 of the constitution. So therein I will be discussing with you article 1, 3, everything in detail. Then next point, the center state legislative relations. The center state legislative relations are based on the three lists given under schedule 7. Full stop. An analysis इसी में लिखना. An analysis of the three lists shows that You can write as A, B, C, or you can write in bullets. I will tell you 3 points here. First, more number of subjects and more important subjects are in the union list. You name any important subject and you will find it in the union list. Then, in case of concurrent list, if both the union and the states make a law on the same subject, it is the union law that prevails. It is the union law that prevails. Suppose the state of Haryana as well as the union government, they have made a law on the same subject. Suppose social and economic planning, it is a subject in the concurrent list. So, if there is a conflict between the union law and the state law, the union law will prevail over the state law. Why? The logic here is that the union law will be valid throughout the territory of India. That is in all the states. So, it will be valid in Haryana also. How Haryana will have a separate law? And then thirdly, so you can highlight this point. Such type of statements will be there in the prelims examination. Then thirdly, the residuary powers lies with the union. Here I have used the word residuary. The subjects not mentioned in any of the three lists is known as a residuary subject. So, our constitution makers, when they were enacting the constitution, when they were writing the constitution, and they were writing the subjects under the union list, state list and the concurrent list, at that point of time they may not have realized the importance of certain subjects. They may not have imagined also. For example, space. Our constitution makers had never thought that we'll have to make a law on space. But when Sputnik was sent, then we realized that we also need to have a space policy. Space was not mentioned in any of the three lists, and that is why it became a residuary subject. It became a residuary subject. Another example, when our constitution makers were enacting the constitution, at that point of time, they had, obviously the technology was not very much developed. Even good quality of the machines were not there. Even the computers were not there. Typing machines were not there. So basically what we see here is that they had never thought about computers. Computers to dekha bhi nahi hoga. They may not have ever heard about it. So they did not mention such type of topics. When we entered in the era of information technology, we felt that we need to have laws on cyber security. Cyber law was not mentioned in any of the three lists. It became a residuary subject, and the central government made laws on it. Then artificial intelligence, the central government is making laws on that, because these subjects have not been mentioned in any of the three lists. That is residuary subject. So if someone will ask you what is the residuary subject, what you will say? That a subject not mentioned in any of the three lists is considered to be a residuary subject. And in the US and Australia, the residuary power lies with the states. Likh lena, you can write it here. In US and Australia, residuary power lies with the states. Lies with the states. So we have followed the Canadian model here. In Canada, the residuary power lies with the union government or the central government. So we have here not followed the American model. In America, it lies with the states. Then, ye to hua 3 points. Some other aspects are also there, but we will be discussing them when we will be discussing the center-state relations. Now, 2 fresh points you write. Ye to 3 ho gaya, the explanation of the earlier point. Another fresh point you can write here, that the governor who is the executive head, of a state government, is appointed by the center, Then, next, the officers of the All India Services, All India mein A will be capital, All India Services, I India capital, and then S capital services. All India Services are appointed by the union government, but they mostly serve under the states. There are many other aspects with respect to this aspect that we have got a strong unitary feature, but that we'll be discussing under the center-state relations in detail, financial relations, administrative relations, so that you will get a holistic idea. Abhi to just I am telling you that if you need to frame an answer, how you will frame an answer in 150 words. Now, that is the logic why Professor K.C. Ware may have termed India as quasi-federal. So, when we conclude, you can write it by way of summing up. We may agree with Professor Alexandrovich WICZ, who held that India is a case sui generis. That is, it is a federation of its own type. It is a federation with strong unitary features. With a strong unitary feature. Obviously, quasi-federal is justified. ऐसे you need to develop the answers. समझ गया? So, from prelims point of view, the theoretical aspects are important. From the mains point of view, such questions are important. UPSC is very fond of asking questions on federalism. So, these were the things that we needed to discuss in today's class. I have to complete this topic. मैंने सोचा कल नया शुरू करूंगा. I'll start a new topic with you. That is why I completed it. So, we'll stop here for the day, and tomorrow we'll start our discussion on a fresh topic, that is the preamble. We'll stop here for the day. Online students, I will meet you in 5 to 7 minutes. म्यूचुअल तो आपस में बात करके, हाँ, एट द सेम लेवल. जैसे मैं आपसे बात किया कि भाई मैं कैन यू टेक सम ऑफ माय पावर्स, यू विल से यस सर आई विल टेक सम ऑफ. म्यूचुअल डेलीगेशन. यू विल आल्सो डेलीगेट योर पावर्स टू मी. हाँ, वो तो जबरदस्ती का कि नहीं नहीं डेलीगेशन है. एंड म्यूचुअल, दैट इज म्यूचुअल. व्हेन इट इज म्यूचुअल इट विल लीड टू कोऑपरेटिव फेडरलिज्म. हाँ, वो that is under article 258, 258A that can be delegated. So we'll stop here for the day.